Tonight, I'm going to be thinking about this broadcast as the record, the rumors, and perhaps the road ahead. Because I want to do three things tonight. I want to document what is happening now, correct the record once, and do my best to explain what I can in part to what I'm going to do next while we wait on the court. But first, let's do a reality check. There is a standing court order that was given on December the 4th, requiring the defendant, Danielle Robertson, to file a written notice identifying her legal name and postal address. The stay on that obligation had been lifted, and the deadline now has passed. It was Monday, the 15th. As of tonight, there is no filing on the docket showing compliance with that order. No written notice, no requests for additional time, no explanation on the record. That is not commentary. That is the status of the docket. I am not speculating about motive, nor am I announcing consequences. I am documenting what has and has not occurred in the public record. In federal court, once a deadline passes without compliance or a request for relief, silence is no longer neutral. I've been talking about it. It becomes part of the case history. That's not drama, that's procedure, especially in the Eastern District of Michigan. Now, the second issue I need to address, and I'm going to do this, I'd like to do it once. There is misinformation circulating about my case, including from content creators and chat commentary and others. So let me be clear. This is not a case that is only about copyright. This is a 6-count federal case. Copyright is one of the counts, not the entire lawsuit. In addition, right now, the case involves identity disclosure, jurisdiction, and compliance with the court orders. Those issues exist independently of copyright and are reflected in the pleadings and the orders on the public docket. This case is not about online commentary, opinions, and personalities. Courts do not decide cases based on live streams or speculation. They decide cases based on filings, orders, and compliance. And one more clarification that matters. To my knowledge, and based on the public record, this case, my case, was the first to result in a court order directing Danielle Robertson to disclose her legal identity. That order exists on this docket. I'm not saying that to claim an outcome. I'm stating it because it explains why this case is being talked about inaccurately. An order like that doesn't come from rumors or drama. It comes from what was put in front of the court. Because there's been so much confusion, and because I've actually never done this before, I am going to shift how I handled this publicly while the court addresses the current non compliance as I see it. However, there are certain things that are misinformation that I feel it's necessary to correct because left uncorrected, it begins to spiral as rumors and just a lot of people aren't fully aware of this case. They haven't read the case. I have never read my complaint to the audience, but I'm going to, not tonight. We're going to take it. There's 6 counts. So yes, I am going to begin reading through my case itself calmly over time in 6 parts, like I said, 1 count at a time. And I'm going to be doing it for a couple of reasons. First, as I mentioned, to correct misinformation without having to engage in a back and forth. Second, to make sure the record is understood while the court does what courts do. I'm not rushing the judge. I'm not predicting outcomes. I'm respecting the process. So while we wait for the court to address again what is going on or not, I will be doing what I've done from the beginning, documenting, now grounding, and letting the record speak. That's where this belongs. So let's get started, but with the complaint. But then I just want to pause before I do. You can email me right now at unwinewithteddy@gmail.com. There's more that I could say right now. I want to do this respectfully. I'll say this. I'm not comparing my case to anyone else's case because as cases have come along, what I've done, I actually read the complaint of the other case some time ago. Um, yeah, well, it's been a while, but I read it uh, last year, if I'm not mistaken. Yeah, it would have been maybe September. Yes, I think that's when I read it. So my case has been characterized. That's what I'll say. My case has been characterized that it is weak, that it is the weaker of the cases. So the only question I'd like, not an answer to, I'm not going to go through debating it right now, but respectfully, I'll just say ask Maggie, since she's mentioned that several times. Why? Why do you specifically think that my case is weaker? Now, whether or not I think it is, I don't. But I just, since that narrative is mentioned, and it is your opinion, and you said so, I'm just curious. Yeah, I'm just curious why it's characterized in that way. Not for not for any back and forth, but I just wonder. Let me just think about this. So I came out and said that because I want to be transparent, and So let me show you, because not just you, but the audience, why and what my case is about. And this would be to clarify it for others who really have not heard about this case. They're guessing about it. They have no idea. Right now, many people just think it's about one thing or not. So I want to clear the record and refer to the record. Okay. So this case was filed last year. It was December the 23rd, 2024. It is now Sabrina Evans versus the defendants, Daniel Robertson and Jane Doe, also known as all of these aliases: Danny Robertson, Danny Montana, Truth Teller Danny, Lori Davis, Danielle Robertson, and two, Jane Doe's 1 through 10. All right. The presiding judges is the magistrate judge. Um, so we have Elizabeth Stafford and we have Judith Levy, who is the district judge. All right. And this is what I've written. The nature of the case: this federal lawsuit arises from a sustained campaign by the defendant Daniel Robertson to harm the plaintiff Sabrina Evans through copyright infringement, defamation, harassment, privacy violations, and cyberbullying. Since 2022, the defendant has repeatedly violated the plaintiff's rights by unlawfully using copyrighted materials and filing fraudulent copyright claims, primarily through impersonation, to commit fraud and damage the plaintiff's YouTube channels, Unwind with Teddy and Run Tell That Too. These actions have caused significant harm to the plaintiff's reputation, emotional well being, and professional career. Plaintiffs Sabrina Evans bring this action against Jane Doe, also known as Danielle Robertson, Danny Robertson, Danny Montana, Truth Teller Danny, Lori Davis, and Daniel Robertson, LLC. The complaint reserves the right to amend to include additional identified or defendants identified as Jane Doe's 1 through 10. Those are placeholders. Jane Doe can be John Doe. It's placeholders. These placeholders represent individuals or entities whose identities and roles are currently unknown but believed to be involved in the alleged actions. This lawsuit seeks to hold Daniel Robertson accountable, secure compensation for damages, and obtain injunctive relief to prevent further harm. Count 1, copyright infringement. Count 2, defamation and privacy violations. Count 3, false reports and fraudulent claims. Count 4, cyberbullying and harassment. Count 5, impersonation of others to commit fraud. And count 6, conspiracy to commit fraud and cause emotional distress. I'm going to pause for a moment. After ECF 75, report and recommendations, and the district judge accept the full recommendations of the magistrate. Some of these, specifically, as it stands today, Count 6, the conspiracy, that was dismissed. Impersonation of others to commit fraud, that too was dismissed. Counts 1, counts 2, counts 3, and counts 4 were not dismissed in full. And since then, there have been filings that we are waiting to get a response on because there has been a motion by myself that was filed recently. And I will get into that later. But it affects the count 6 that was dismissed. I'll say the count 6. But if that gives you just a sense, it's not just copyright. And I think, like I said, I think it's important. I think it's important to have dialogue, and I think it's important to be transparent. And I think it's important at this point to identify things that I see that are misinformation about my case and use the record to make those corrections. Because do I expect people to know about my case in detail, in depth? No, I don't. But things that are, you know, very important that I see or hear that I think needs correcting or at least brought to, you know, light, then I'll do that. And I want to do it in a way that is respectful. Okay. Again, I think just that alone, what I've showed you from the case, that should help to clear up some of the repeated confusion about this, the counts. All right. I read it straight from the pleadings and or public. Dismissal of some claims or motions does not equal dismissal of the case. The litigation can often narrow issues without ending that action. Right now, there is in front of the judge ECF 77 by the defendant to dismiss this case. And also, there have been subsequent filings, information that can impact this case, depending on how the judge rules on it. So, again, parts of the case or parts of motions have been ruled on at different stages. This is normal for federal litigation, but the case itself is still active. No final judgment has been entered, nor have I said that I've won, nor have I said that I've lost. I've just stated where we are. And with this new, where things stand, we're waiting to see how the judge responds to what is going on now. Another misinformation, perhaps. Nothing else matters except copyright registration. The case involves, like I said, identity, disclosure, jurisdiction, compliance with the court orders, all of these things, threshold things that we are dealing with, still procedural issues independent of copyright registration. So the application that I submitted for copyright for registration, it was refused. Okay. The court is aware of that. There have been multiple filings, and at some point, I will read those as well because I think they're important. All right. And there are rules. Doing great. Thank you. All comments and opinions of the chat are allegedly, allegedly. Yes. And again, everyone is welcome um, to this platform as long as the comments are respectful. All right. So now let's take a look at copyright infringement and what I filed. We're going to start with count one. Copyright infringement. On or around April 11th, 2024, defendant Daniel Robertson unlawfully obtained and used copyrighted images and video testimony of the plaintiff, Sabrina Evans. These materials, created on April 9th, 2024, during a closed hearing on Petition for Personal Protection Order, PPO, in Wayne County's 3rd Judicial Circuit, are protected under the Copyright Act of 1976. Facts supporting the claims. Ownership. The plaintiff owns the copyright to her personal image, likeness, and video testimony depicted during the hearing. These materials were fixed in a tangible medium during the proceedings, and copyright protection was automatically conferred upon creation under 17 U.S.C. 102. The plaintiff retains exclusive rights to these works, including reproduction, distribution, and public display. Exhibit A. I have already told you what the response to the image that I submitted to the Copyright Office for registration. All right. There was a refusal. There are rounds that I can take, but I'm not prepared to get into that right now. All right. I am going to be transparent because things are on the record. This is all under copyright infringement. This is the count. I wrote it. Unlawful acquisition. Listen carefully. The defendant conspired. This is what with the PPO petitioner to unlawfully record or access the private court hearing. The PPO petitioner either directly provided the unlawfully recorded content to the defendant or facilitated real-time access via phone. I said phone. Exhibit B. Unauthorized use and distribution. On April the 11th, the defendant publicly disseminated portions of the recorded content during multiple live broadcasts on her YouTube channel. Specifically, the defendant shared details of the confidential PPO hearing during a live broadcast titled Black Tea Sector, Teddy Bundy, The Real Tea, April 9th, Exhibit C. The defendant altered the background of the image depicting the plaintiff during her closed hearing testimony without modifying the plaintiff's actual likeness or appearance, and subsequently published the altered image in a monetized YouTube video, falsely claiming that these changes constitute fair use and transformation of the original work. Exhibit D. The defendant created and disseminated explicit deep fake pornographic content using the plaintiff's likeness on ican't.com and YouTube channel Unhinged with Bundy. Exhibits E and F. I should say also, in those counts 1 through 6, inside of those counts was the deep fake pornography creation that was dismissed because the magistrate judge could not see the link of those to jurisdiction. To jurisdiction. I'm not going to argue, but I have submitted new information that will support the deep fake pornographic count or that portion of it. I'm arguing now that it should be considered to be part of this case. Okay. Not going to go into the arguments and how this came about, but it's in there, and this is really important, and this is why the defendant is arguing now. All right. This case is deeper than just copyright. People that put things up in the comments and said, oh, this case is frivolous, this case is just copyright, they haven't read the case. I don't know how it's going to go, but I'm just giving what's the case is about and what I brought. All right. Next, this is all under copyright infringement. And by the way, I'm sure you listened to that carefully. So that picture, it was obtained unlawfully because that was a closed hearing and it was stated that picture got out. It didn't magically get out. Okay. Again, I'm not going to argue. I have my arguments in subsequent filings, recent filings. Okay. And the conspiracy part was dismissed because there was, I didn't show meeting of the minds, it's called. Prove the meetings of the mind, because conspiracy has to be two people, and there's a legal argument. Okay, let me continue. Exploitation. The defendant used the copyrighted material to humiliate plaintiff, harm her reputation, and cause emotional distress. The defendant also profited from these actions through monetization on social media platforms. Exhibit G. Additional information relief requested. An injunction prohibiting the defendant from further use or dissemination of the plaintiff's copyrighted materials. Statutory or actual damages, including profits derived from the infringement, attorney's fees and costs, compensatory damage for emotional distress caused by dissemination of explicit deepfake pornography, any additional relief deemed by the court. Okay. And I will leave count 2 for next time. We wouldn't be talking about that specific image if it hadn't found its way outside of the PPO, private hearing, and it was stated it's unlawfully obtained. It's not supposed to get out. So, again, characterizing my case, it's anyone's opinion. Characterizing my case as the weakest or a weak case. I'm just curious, what are you basing that on? I really want to know. I'm just kind of curious. Yeah. But you're not a lawyer, and neither am I. And everybody has an opinion, and we will see. but on the merits of the case. This is a process, and we haven't even gotten into. Let's not forget the district judge, had moved forward. Cyber bullying, harassment, defamation, the police reports, the contacts into Michigan, to the medical board, the people that I see putting things into chat, they haven't a clue what the case is about. And so then the misinformation that's getting out there is being, said. And people are going to say things. So I just thought I'd come over here. This is my platform. And for those that want to now actually hear what was filed on record, I'm going to share that with you. This is the first time I'm doing it. I have not done it. Again, I don't know how the case is going to, I don't know the outcome. And I appreciate the conversation about my case. I appreciate the interest in the case. I think it's important to get the facts right. Yeah, that's all. And people are going to talk about it. They're going to have their opinions. I can't stop that. Misinformation? Yeah, I can speak on that. Yeah. And people can keep misinforming. But at least I need to do my due diligence to correct the record because this is my case. And I think when I've talked about other people's cases and or their complaints or anything like that, I've been respectful and I've stuck with the facts. And I haven't disrespected their ability to pursue justice for themselves. Because what everyone has experienced, they have experienced it. And we're talking about the same individual at the center of all of this. And no, this is not a contest. We're going to throw this up. So then this can be clear. This is not a contest between creators. No, it's not going to be, oh, you get first prize, you get second prize. You win gold, silver, and bronze, or not. No. I'm not trying to do something to undercut any other person in their pursuit. Not me, not here. What I'm focused on, because ultimately it will affect everyone else, is the identity of this individual that has been ordered. Because now people talk about it, right? They want it. But I brought it forward to the court. And we might not be talking about it if that wouldn't have happened. That's why I just gave her two questions. I would just really like to know, why would my case have been, why do you think my case should have been dismissed? Because maybe I can learn something. Maybe there's always something you can learn. And yeah. And why do you think my case is weak? Maybe that's all in the same explanation. I don't know. But yeah, if you care to, can you expound? Yeah. We'll continue with this part, count two, and we'll go through them. And maybe after I go through them, people will see what this case is about. All right. That's going to do it for me. Please hit the like on your way out. Email me at unwinewithteddy@gmail.com. But now it's time to say goodnight because it's midnight. Thanks for watching. Until next time, I'm Teddy. Good night.